Hi everyone, this is Grant Abbott speaking, and I'm just here discussing with you how to protect your companies with the Successor Director solution. This is a special purpose solution which is offered through LightYear Docs in conjunction with Abbott and Mourly lawyers. So it's a very exciting one, and I want to show you how it's probably one of the easiest solutions you'll ever have, and more importantly, it's one that is really going to make a difference to your bottom line. A couple of things though, where to find this replay afterwards, all upcoming events and any important issues. This is your Surge app. If you haven't got the Surge app, make sure you just contact our offices, support at lightyeardocs.com.au, and we'll provide that Surge app for you, the access to the new LightYear Docs 2 portal, as LightYear Docs now, the original one, is now shut down. If you haven't got the Abbott and Mourly app, likewise, we are a separate independent company, so they don't talk to each other necessarily. You can get through to seek legal review on any particular issues through Abbott and Mourly, but go onto your Play Store or your iStore, or effectively go on and download the Abbott and Mourly app, and that enables you to ask us technical questions from a legal perspective. Obviously, any support questions, you'll go through to LightYear Docs. So this is now the place to be. A lot of money has been invested on this side of things, so make sure you get out and have a look. We've got a few things coming up. Next week, I've got my 4th to 6th of April. That should be 2022. We've got the SMSF accreditation. This is the third one. It's going to be a very exciting one. So if you are along on that one, if you haven't got your ticket yet, have a chat with Talitha, T-A-L-I-T-H-A, at lightyeardocs.com.au. On the 7th of April, we've got our Suite of Trusts presentation, which will be a very exciting one on all our various trusts, from our Family Protection Trust to our Leading Member Trust, to our Hybrid Trust, our Suit Trust, our Declaration of Trust. It just goes on, LRBAs. The week after, we're still working out the date, is our most important launch, and that's the new Martin Castle. For those of you Australia's members, you can go and have a look and play around with it as is now. There's still a little bit of work to be done, but it's very exciting, combining more than 38 documents all into one interview platform. Anyway, let's start the day and really have a look at the problem of litigation in Australia. You may not be aware of it, but per capita, Australia produces the most amount of lawyers in the world. In fact, New South Wales is the leader, and particularly with traditional legal work drying up, litigation is becoming all consuming, along with the fact that now lawyers can advertise. You see, I did a session driving from Sunshine Coast to Gold Coast only recently, and on that trip there was 4 billboards from lawyers who are offering no win, no fee opportunities, particularly around superannuation and disability claims, but more importantly in litigation around family provisions claims. So if there's any way that they can get their leak in there, they will. From a perspective of any professionals, we're obviously all in the firing line, as many of you well know. It's nice to say that your PI will cover you, but at the end of the day, PI lawyers can find out easily, get away from making a payment. If any payment's made, it can take years. So don't expect your PI insurers to really come in and stake a claim. For example, we may not be aware that under superannuation, potentially any breach of the SIS Act is a Commonwealth crime, and you'll find that most crimes are excluded from your PI policy. Now, not only is it us professionals that really need to make sure we're protected and put moats and castles around ourselves, this Successor Director solution, but all companies, all directors are now in problems with those sort of things. And particularly with ASIC is taking a very hard line on issues now. You've seen me talk about this before. This is the Miller and Taylor case. You know, it's not just the only one. It's a case that's pretty relevant to everything, that once you get mired into litigation, it's a very, very long and expensive process. And the reason it's long is that if you go and have a look at any particular litigation, more often than not, you can end up paying for a senior counsel, junior counsel, solicitors, for a day hearing in court, and then find out that, lo and behold, essentially you're in a position that there's a continuance. One of the lawyers hasn't got enough information. They ask for a continuance, and you're up for easy $20,000 to $30,000 a day. Obviously, our goal here is, like your docs, Abbott Mourly, and you as advisors, using our systems, is to really get in and protect a family's castle, which includes all their assets, their family wealth, etc. So really, it's an absolute crucial for us to do that. And the successor director solution is like no other. Generally, the charge for a successor director solution is $550, not from our end. If you're a strategist member, you can do as many as you want through our multi-platform ability. If you just pay as you go, you can do the successor director solution for the price of $129. Mind you, all of our companies now have the successor director solution built in as an option. You can't get better value than that. Now, in terms of the successor director, I just want to drill down at the moment and just really look at directors as a whole. Obviously, if you're acting as a director of a company, as time goes on, it's not as it was maybe 20 or 30 years ago. You simply put anyone as the director, you go off, sign off. That's your new requirements under ASIC to do your annual company returns, etc. But these days, directors are really pinged for anything that the company does. So that not only will you take action against the company, you're also going to take action against the directors of the company. And that means a problem that if they're sued, then they're really in the firing line, which is okay, but it's more importantly being able to get out there as a director. But if the director's incapacitated, what happens to that company? And more importantly, if the directors die, and don't necessarily assume that you've got mum and dad as directors, and as a consequence of that, that they are going to be in a position of that one of them's going to continue on the company. What happens if they both die together? So really, it's really, you've got to be really careful when it comes around a company to have that succession in place. If you've heard me talk about this in the past, to make a really good family wealth protection, you need to have succession. That's your key. It doesn't matter whether it's a family trust, family protection trust, whether it's just a bucket company, anything to do with companies, we need to have that plan of succession. And of course, incapacity and death is a great problem in terms of succession. More importantly, obviously, when you die or become incapacitated, you're not able to act as a director, obviously. And if you die, you can't be a director. So there's obviously issues there. I've heard a number of lawyers put in place that, well, it's easy just to put in an alternate director. Alternate directors are fantastic if you're going overseas or someone else comes in to take your place, but they're actually taking your place. Whereas with a successor director means that you are effectively out of the picture and someone else comes and succeeds from you. Alternate director, it just means that they're in there as a casual vacancy. Many people aren't probably aware, and certainly many lawyers aren't aware, that an alternate director lapses on death. Now, the issue of what happens to a company in the event of the death of the directors of the company has been subject to a guidance statement 73 by ASIC in the early 2000s. So really, as accountants and all professionals, we need to be aware that ASIC has provided guidance to this. And certainly, if there's ever litigation against the accountant for not providing a successor director solution, you are certainly going to be up for negligence. You can't argue that you weren't aware of guidance 73. So let's have a look at that guidance there. It's embedded, it's quite a lengthy guidance, maybe 3 pages. You'll find as part of the successor director solution, it's actually embedded within that solution, which is okay. But here what we've got is that during the ASIC provides that during that period where there's no director, the company may be completely unable to operate, which is pretty obvious. And that also includes trustee companies, which we want to look at very shortly. With no one properly authorised to make management decisions or act for the company, that may be unable to trade, Banks and other financial institutions in particular may be unwilling to accept instructions in relation to the company's trading account if they're not satisfied there's someone properly authorised to act for it. Equally, staff and suppliers may not be able to be paid, which can quickly have a deleterious effect on the reputation value of the company to the beneficiary of the estate, which means they may not well be able to sell it. So it's really a fairly important issue to make sure we've got that succession. The LightYear Docs is, at this stage, the only company in Australia that provides a successor director solution. I'm going to show you the exact wording in our standard company. It also applies in all our corporate trustees as well, including SMSF corporate trustees. Just as an aside there, under section 17A3, we are limited by who can step in as a corporate trustee director, and has to be the executor. So if you're doing a successor director solution for an SMSF, then make sure it is the person who's going to be the executor of the estate in the event of the death of the director. That's the SMSF corporate trustee director. Abbott Mourly's work with LightYear Docs to ensure the successor director solution is available to all of our companies. It's very easy to upgrade a company under Section 136 of the Corporations Act with a shareholders meeting. Essentially what it does is it provides a director substitution clause, and that's embedded into the company. If you haven't already got one of our standard companies, you can upgrade it. If you've got a standard company with different classes of shares, there's a button in that upgrade clause where you can keep your existing class of shares or utilize the LightYear Docs company. If you haven't seen our session, we did quite an extensive session on companies last week. Not only will you get, obviously you need to upgrade the company constitution, but you need a set of binding minutes, which are forward-looking binding minutes, so that in the event of death, incapacity, bankruptcy, or some other reason, that the current director resigns and a new successor director is appointed. And again, let me just say that again. So the current director resigns and a new succession director is appointed. So that means that although we're putting in this binding resolution, effectively, it means that there's no requirement to notify ASIC at this stage because it's a forward-looking binding resolution. The current director stays on, but if something happens in accordance with that resolution, then a new successor director comes on. Now, with that one, we also provide a deed of indemnity, so the successor director is not going to be bound by any actions of the company prior to that stage, so that effectively there's an indemnification from the company's assets for that successor director. So it's a really good, strong package. Originally, we only just provided the binding minutes, and that's one of the weaknesses. If you use our EPOA successor director solution, you can only really use it with LightYear Docs companies because it's an assumption there that there is already a clause within the constitution to enable the successor director, but it doesn't provide a deed of indemnity. So if you're looking at doing a proper successor director, then the best thing to do is obviously use a LightYear Docs solution. And sorry about the banging, there's a little bit of renovation going on outside, so hopefully it's not too annoying for you. If we go down to a typical clause for the LightYear Docs that enables the successor director solution. So let me reiterate again, if you get a LightYear Docs corporate trustee or company or bucket company, automatically embedded within that constitution is the ability to put in place a successor director. So clause 45.5 of our standard company provides as follows. Any director may request the board of directors to put in place a binding resolution that a successor director will take the requesting director's position as a director with full rights, entitlements and privileges that the position ensures. The binding resolution to replace the requesting director is to lay out the circumstances as to when the successor director is to replace the requesting director, and may include that the requesting director cannot manage the company because of mental incapacity, becomes bankrupt or dies. In addition, the person will represent a trustee, the person may appoint a successor director. So we've even taken a little bit further, which is quite useful because, again, I've seen too many lawyers argue that a person who has a individual's enduring power of attorney can be a director of a company. Well, that's not the case. It's essentially going to require the individual themselves or the corporate constitution to enable it. So as we go back to ASIC guideline 73, we can have a position there whereby someone dies and really the company is virtually exposed. And that's your bucket companies, your trustee companies, your trading companies, and really the company being utilised for any purposes. Now, on top of that, so there are standard companies. I just want to point out also the corporate trustees are really important as well. So if there is an issue there with a corporate trustee for a SMSF, discretionary trust, then essentially what happens there is that, for example, SMSF, if the directors die and a new director can't be appointed, then effectively that trustee is null and void, which means that under superannuation law, section 19, the fund can no longer be a regulated fund. And in particular, it loses all its concessional tax status. Now, you don't want that. Again, if you're doing a successor director solution, the person who must stand into the breach as successor director is going to be the executor. For a discretionary trust, you don't need to do that, but you can imagine that if a discretionary trust has a corporate trustee that doesn't have any replacement, then you're in a big issue. Now, there was an argument I got into with a lawyer the other day in relation to saying, well, it doesn't matter because on death, the executor has the ability, is going to end up with the shares of the corporate trustee and they'll be able to appoint a director. Well, that's right, but a no-win, no-fee lawyer, if I was on that case, the first thing I would do is I would grind down on that executor and say you're not to appoint a corporate trustee, a director to the corporate trustee, or more importantly, I'd like one of my representatives to be the director of the corporate trustee. And that would mean that we'd end up getting into quite a significant fight. And I've seen cases of that. I pointed that out to the lawyer that in some instances, it could be like 2 to 3 years before that is up and running. And then suddenly we've got a position of a scenario whereby that SMSF or that discretionary trust virtually out and no one can even sign any documents, lodgements, tax returns for that period of time. Of course, you can't lodge a tax return without the directors being able to sign. If you do so, then obviously there's major concerns there as well. As I said, if the opposing counsel freezes you out, then essentially you're in a pretty bad position. One thing that I just wanted to note for you is that, again, that issue of shares can have a problem. It's great to have a successor director solution, but you don't want those shares to go into the estate. If they do go into the estate, then obviously that's where a family provisions issue can arise. Same with family law, same with a whole range of issues. So in that instance, it's best to make sure that we have a leading member corporate trustee who essentially can be in a position of looking after that particular company. So we've got special purpose corporate trustees for a leading member discretionary trust and also family protection trust. What happens on there is that we have our leading member, our family protection appointer. They are the persons who really look after they're the persons who really look after the company and appoint the trustees. Now, in that instance, what happens on the death of the leading member appointer, their shares, and they're the only shareholder of the leading member corporate trustee or the family protection company, their shares are cancelled and new shares are issued to the next leading member appointer. So it prevents anything going on to the estate. So let's stop and have a look at let's go and have a look at, sorry about this. Let's stop and have a look at our solution at LightYear Docs and Abbott Mourly. Now, before we go to, sorry about that. Before we get to the having a look at how to do the successor director solution, I just wanted to start at a really high level. So we've talked about why we need it, when we need it. Just be careful though, for corporate trustees, we might be better off using our special purpose leading member corporate trustee. But again, that's one of the issues that I had a look at. last week when we did the House of Companies. So have a look at that. But here's our business success tool. If you haven't got a copy of this, have a chat with Ben from our office. So just Ben at lightyeardocs.com. He has the business success tool that you can look at, which will show you the sort of money that you can make using our solution. So LightYear Docs isn't just a document platform, it's a business strategy solution. Here, we've got a whole range of relevant pricing for each and every solution. The Successor Director solution, most of our advisors and accountants are charging $550 for that. So for example, if you've got 300 companies in your suite, then that's going to be $165,000 of revenue. So it's a really good one, nice and easy one to set up and start off. So how are we going to do it? Well, the first thing we do is go to our Surge app. Most of you should be aware of, you've got your Surge app here now. You've got your quick links. What I want to do now, I'm going to go to the document wizard, but before that, I want you to go to the support site. So you'll find in the support site, as we go through, and this is being recorded, so you're going to get the recording of this later on. Remember, I said you get that in your Surge app as well. We go into our resource section. You'll find in that resource section that there's actually a whole lot of email copies done for you. See that one there? Successor Director Sales Email for Clients. So for that one, all you can do is you can send an email out to your clients, either specific clients that you want to, just what happens if your company, and you'll see there's quite a lot of copy down there. So we've got, for example, what happens to your companies if you die, get sick, or litigate against, or become bankrupt. There are almost 3 million companies, in fact, we've gone over 3 million companies in Australia, many used by small businesses to trade, and for others, companies act as a trustee, a discretionary trust, or a self-managed super fund. However, what happens when the director of the company, trading or trustee, dies or becomes incapacitated? Will the business fail? Will it go into a long, slow hibernation until Supreme Court legal action is taken to install a director or new trustee? Will the company be taken advantage of by existing directors? So successor director is also just as important, for example, where you've got trading companies in conjunction with other families or other businesses. Just as important, you need someone there to protect your family wealth or client's family wealth. Will lawyers seeking to make claims against the estate lock up the company or put their favourite director in? For SMSFs, will the ATO install their directors? So these are all relevant questions. Any of the above reasons can spell disaster for a company, trust, or SMSF. We've seen cases where a company has run into the ground in a short space of time because there was no director, and the accountants and lawyers to the company did not realise the director's will is ineffective to appoint a continuing director. For this reason, we advise all of our company clients to ensure that a successor director is in place. What is a successor director? The company constitutional rules, not the will or any enduring power of attorney, may provide for a person known as successor director to take over from a sole director or director of the board when the current director is sick, dies, or subject to litigation, including divorce or bankruptcy. The current director is automatically removed and successor director appointed. Case study. John Smith runs his trading company as the sole director. He has 10 staff, is very hands-on, but his staff do not know what to do to keep the business running. He's also the director of the trustee companies for his family trust and self-managed super fund. John dies in an accident, leaves behind a business, wife, and 2 young children. John's family wealth is exposed, as are all of his structures, as we've explained previously. Who will pay the bills? Will his family be able to access any money, even for the funeral? This is only the tip of the iceberg. Wait until the bank starts to threaten foreclosure on the family home from lack of funds because there is no guiding light to any of the companies. But John's accountant has put in place a successor director solution for all his companies. On John's death, his brother Nigel is appointed as successor director the next day to keep an orderly transition of business, the family trusting SMSF. The funeral is paid for and ongoing income is paid to the family. So all is perfect. So what is involved? To put in place a successor director solution, we need to first upgrade your company constitution to enable successor director. Then we complete a binding resolution signed by the current director or directors, which will auto install the successor director in the event of death, disability, bankruptcy, litigation, for any other reason. There is no need to inform ASIC at this time, but if it is used, then ASIC is an important cog in the wheel. It's important to do now. If you have a company and don't have the successor director's solution in place, you are exposed. You can go to a legal firm, so make sure you get that. I might go and change it to a legal firm and get an updated company constitution and binding resolutions for each company, which will set you back $1,200 per company. Or as your accountant, we can provide the successor director solution through our legal title with Abbott Mourly for only $330 a company. So this was done a while ago. I put it up to $550 because it now includes the deed of indemnity as well. Just to do a deed of indemnity usually costs between $750 and $1,250 from a legal firm. Protect your family's interests and wealth now. Simply email us. We'll work on the project immediately and invoice you next month. So again, that's a nice little copy. You can just simply copy it, put it on an email, send it out to all your company clients if you want, and then just do a follow-up or just start in batches for your clients. Now, I think most people are really surprised when they come around to it and they say, oh, well, that's great, but how do I go about doing it? It's probably the easiest money, honestly, to make in your life. First off is that it's really a requirement. You can't say, look, ASIC is wrong on this one. You really need to go in and do that successor director solution. So I'm just going in and I'm looking at my documents. I've got templates. I'm actually going to build one quickly for you. So you've got that email, you know the pricing, and then what we want to do is we go in successor director and up will pop there. Now you've got two here. This single company plus the upgrade and indemnity, that's essentially just for individuals on pay as you go. For those of you who, like me, are effectively, and I'll just put here, Abbott is the solution. For those of you like me who are the strategist, then essentially what happens there is you can do multi-companies at once, which we'll start to have a look at. So the interview will pump along and it just shows you how fast, and look, I'm sitting in a place that hasn't got the highest speed internet, so it's pretty good. Remember, at any point in time, we can preview the document. You can save the materials as you go through. I've got the Abbott SD solution. I'm going to put in LightYear docs. I'm going to actually put in the Abbott and Mourly logo. So all I have to do is a pretty simple process. You just go to your pictures. Here I go. There's my logo. Up we go is Abbott and Mourly off and running. Now that's now loaded up there, so you can see Abbott AMJPEG. Now I like Abbott and Mourly to be quite big, so I go 8 and then go 5. So that's because it's a rectangular shape. So 8 by 5, I'm going to line by the left. It's legal disclaimer, so that's more about copyright and all that. You don't necessarily need to do that. Now I'm going to go back and I'm going to put the general information. So when's the resolution and all that? I've got the client coming in and I've booked a meeting in April and they're coming in on the 5th of April. So I've set this in place. If you don't know when they're coming in or you're going through, the good thing about the successor director, particularly the company side, is you can use our new FuseSign app in order to sign. So because it's a company, it's governed by the Commonwealth law, effectively you can do electronic signatures. The only problem you have is with the deed of indemnity, which generally requires a wet signature. So let's add the company information. So the first one here is, does the company constitution need to be upgraded? Yes, because I've got an old shelf company. Now what I'm going to do is, it's just a standard company. So what I'm going to do is upgrade to LightYear Doc standard company. Remember, that has that 45.5, which enables us to do the successor director. So we've got a choice there because we're upgrading. Do we want to keep the original share classes? So what it does is it upgrades everything in the constitution with the exception of the share classes, or do you want the LYD standard share? I'm going to keep my retaining all existing share classes. So far so good. So let's go in and we'll put Abbott there, Proprietary Limited. We've got our ACN there now. I'm just going to use 5 Smith Street, New South Wales. Again, the good thing about this, the email I've got John Smith, so I'll just put Grant Abbott @gmail.com. So that's okay. So that's okay. So that's pretty easy. Okay, so add a current director. So I'm going to put there Grant Abbott, gender, male. I prefer not to say, I love that. Gender neutral. Is the director part of the successor director solution? Yes. Is the director a chairperson? Yes. So again, it'll come out because this is part of this. Remember, binding resolution and constitution upgrade. Would you like to add a successor director? Yes. So the first one I'm going to do is I'm going to put a successor director. I'm going to put in place Tony Willis. So that's all sitting in there. And he's in Victoria. And Tanner Willis. So if you ever need to contact us, Abbott Mourly, what am I doing? Abbott-Mourly.com.au. So, okay, so what I've done there is I've put in the details of the company. I've done a company upgrade. I'm keeping the original class as shares. I've said that I'm the successor director. I'm up the successor director solution. Set up the binding resolution with myself as a chairperson. If my spouse is in there, then I can do that. My successor director is Tony. Do I want to do the deed of indemnity? Absolutely, because Tony wouldn't go in there if I didn't do that. And then I just simply confirm it. So that's okay. So I've got a successor director. I've put that in. We've got Tony there, but what if Tony's not alive? What do I do? Again, remember, succession. So I need to put in place a second person. So I'm going to put in there, add a successor director, and I'm going to put in a good mate of mine who is John Smith. So again, lives the same place as me, so don't worry about the addressing. So we've got a second one there. Deed of indemnity for John. He may not want one. He might say, well, no, it's not really an issue for me. So what I've got there is I don't do a deed of indemnity. So I'm going to confirm. So there you go. I've got the successor director, second successor director. We've got the deed of indemnity. Do I want a third successor director? No, not at all. So not keen on doing that one. So there we go. We've got the company constitution. We've got the current director. We've got the shareholders and members. So now I need to upgrade the shareholders. So I'm the, let me just put in the cap there. I'm the only shareholder. So it's very easy to upgrade from that. So I'm just going to confirm, but obviously if it's husband or wife, then you can put that in there. Fantastic. So this is where it comes in. Oops. I've also got a trustee company for my SMSF. So does a company need to be upgraded? Yes, because I've just got a standard old share company. What I'm going to do is I'm going to upgrade it to my special purpose SMSF corporate trustee. So it's going to be Smith nominees. So that's fantastic. We've got our ASIC in there as well. We put in the address, which is 5 Smith Street, Sydney. Now the current director is myself. So I'm going to put Grant Abbott there. Gender, male. Is the director part of the successor director? Yes. You can see defaults. Are they chairperson? Yes. Now the successor director, remember we're going to put that in, but this is a SMSF trustee company. So remember who we said has to be the successor director. I'm going to go yes. I'm going to have to get the will out and find out who's the executor of my will. So again, we might have Tony Willis. So he's the executive of my will anyway. So we put him in, and then there's Victoria, and then it's Tanner Willis at Abbott-Mourly.com.au. It's always good when you're doing these to make sure your Google Capture comes on, because we'll always pick it up. Would you like to add an indemnity agreement? Definitely put yes there. Okay, so I'm going to confirm that. Now, would you like, well, I've done the successor director. I've got the second successor director. Do you want to do a third one? No, because I've only got one executor, so I'm precluded from doing that one. So yep, so I've confirmed that. So I've got all that sort of stuff. Shareholders. Now I'm doing the constitution. The only person the shareholder is myself. And then I can confirm that. So I've got two. And you can see that's how quickly it is to do two companies. You can do 5, 6, 7. I've done 9 in this session, so that's fine. Now we've got to go, the deed of indemnity, we'll choose New South Wales. That's all we've got to do. And then I assemble the documents. That's how easy it is. And remember, I've just made, out of that equation, I've done company constitution upgrades, put in successor director, and the cost for the client is $550 each. So that's a $1,100 package that I am sending out. Importantly, from the strategist, you can do that as many times as possible. Now, when you go through, you get a legal review, but you don't really need to because it's pretty simple. We've encoded all the legal technicalities within the templates. I can download the PDF or I can order that hard copy. I'm not going to do that, but you know, make sure you look at ordering hard copies, particularly if you've got Moat Castles, etc. So I've downloaded the PDF, and here's the successor director solution for us. We'll have a look through that and then we'll sign off. So with the successor director solution, this is for Abbott, we saw there. As I said before, it's important in there to put in the substantive evidentiary documents from ASIC around why we're doing that. Because if anyone says, well, why are you doing that? We'll say, well, hold on, because of ASIC guidance 73. The worst thing is there's, as I said, 3 million companies out there. I think there's about 3.2 now that don't have a successor director. So that potentially puts all those people who establish that, or certainly the accountants who are running the accounts for the businesses, acting as the business and corporate managers of those clients, at risk, because again, have a good look through this ASIC guidance there, puts them at risk. So we've done the constitution upgrade to the LightYear Docs one. It's a special resolution one. We've put it in there for Abbott. So this just simply upgrades the resolution. So we've got the constitution there, and then that goes through from that one there, which is perfect. So we go, you can see here, because we chose that, which is fantastic, all current share class that we retained. So it takes everything and you keep your existing class of shares and everything is then retained. So great little option. You won't see that anywhere else at all in Australia. And for you to be able to do this, it's just like, I mean, it's just so powerful, it blows me away. You know, $550, you should probably be charging almost $1,100 per company just to change the constitution by go to a lawyer and ask them. It's going to cost a lot. Oh, we just slipped past there. Remember the old 45.5? You can see that's embedded. That's why we're putting it in. So now we've upgraded the deed, and see how everything is in line, because you don't do the binding resolution before you've actually upgraded the deed. You have to upgrade the deed. So when you're signing, you sign it in that line. And so we've not only delivered the documents, but we're also putting a signing solution in our execution solution. So there's evidence there of what's happening. So successor director solution, again, to ensure the continuity of company decision-making, company decision-making director seeker appoint a successor director of Grantly Abbott where he's lost his decision-making capability, blah, blah, blah. So we go down there, again, you can see I've put in lowercase, so just be careful with your uppercase when you're putting your names in there. So effectively we've got there, we've got a signing. It's signing not only for myself, but also the successor director. So we want to make sure that they're aware and able in that. So that's a new feature of ours. And then we do a deed of indemnity. So this is a pretty robust deed of indemnity. We've got there indemnified by the company there. And so we've got all the addresses. That's why it's also important to have all the emails in there as well for address of notices for the deed of indemnity. And then that's it. And then we can go down and we can have a look. I won't go in. This is the special purpose corporate trustee, same thing, ASIC 73. But remember, there's no deed of indemnity here. We upgrade the constitution to our special purpose SMSF trustee company, and then we're off and running, and then there's a binding resolution at the end. So again, pretty exciting sort of stuff to be offered to your clients. Very simple. If you really understand the concept, the main thing is to go and market to the clients. And remember, send this out. If it was me from a legal liability, going back to what was said that as professionals we're all liable, I would send this email out to every client who's got a company, whether it's a corporate trustee, bucket company, doesn't matter if it's a company, send this email out to them, absolutely essential, because at least you've gone on the front foot and said that, yes, look, it needs to be done. Clients might say, well, you know, why haven't we done it before? Just say, well, look, this is just something that is now being looked at by ASIC, so it's absolutely crucial to put it in place. Charge a fee, and even if they come back and they don't take it up, at least you've got an email there that you've notified them. Anyway, that's about it for me. Sorry about the renovations and the noise, but all very exciting. As I said before, LightYear search is where you're going to find this replay. Watch out, SMSF accreditation. I've also got my SMSF course starting from the 9th to the 11th of May. If you can make along to that, that'd be fantastic. And also Moat Castle, watch out for that one, strategist only, but certainly if you're on PAYG, you're going to want to upgrade from PAYG to strategist, because this is absolute mind bender, even only if it's for your personal circumstances. You're going to be able to do a whole lot of stuff that really fits in with this as well. Anyway, we've got to the end of the presentation. It's Grant Abbott signing off from our Successor Director Solution.